Okay, good afternoon and welcome. I'm Ross Chait, a professor in political science, and now I'm at the Watson Institute. And I'm delighted to welcome you to Constitution Day. This day is, in the nomenclature of public policy, an unfunded mandate. If you know the history of Constitution Day, it came in, I think, 2004. Senator Byrd added an amendment to the omnibus funding bill that said all institutions that get federal money have to do an event on Constitution Day that's an educational event. So here we are. But fortunately, we do have funding. It's not from the federal government. It's from the Political Theory Project. So we're much better funded than we might have otherwise been. And I want to thank Professor Tomasi for giving me the chance to invite today's speakers and to suggest this topic. And I want to thank Mary Masad for all her hard work in organizing the event. As you know, our forum today is on the special challenges of the Confrontation Clause as they arise in cases involving children and child abuse. And we have two really fabulous law professors here. I am so delighted that they're both here. Our format is going to be, I've asked each speaker to talk 15 or 20 minutes. And then I've also asked them to both do maybe a 5-minute response that might sharpen the areas of disagreement. These two are so civil that I think they're going to largely agree. But I know there are things they disagree on, and I want to make sure you know what they are. So our first speaker will be Professor Richard Friedman from the University of Michigan Law School. I think it's fair to say he is the premier scholar in this country on the Confrontation Clause. And if you're really interested in the Confrontation Clause, he has a blog devoted to the Confrontation Clause. And our second speaker is Tom Lyon from USC Law School, who I think is the premier legal scholar in this country on children as witnesses. So they come at this from different backgrounds, but they're both eminently qualified. And I'm really delighted that they're here. So please join me in welcoming both speakers. And we'll just let you start.
Should I stand? Or?
Your choice.
I'll stand. So, no, you know what? Then I'm off to the side, so I'll sit here. I might as well be looking straight at you. So, thank you very much for coming. I want to thank Brown and the Janus Project and everybody associated with it for inviting me and for putting on this this program. I organized Constitution Day, the observance at my own university, so I ducked out of town for this year. It is ironic, Ross mentioned the unfunded mandate, and many people think that the requirement of Constitution Day is unconstitutional, that the idea that as imposing a condition on receipt of federal funds, you take on the obligation to put on a program. Personally, I think it's an appropriate constitutional condition. In any event, I think it's really appropriate for a great university to devote a little bit of time in a program to commemorating the anniversary of the United States Constitution and to contemplating some of the issues surrounding it. And so today we're going to talk about the Confrontation Clause and in particular how it applies or not to young children. It's a very old topic which has been refreshed and dramatically altered in recent years and in recent months. So I'm going to start by giving some background on the confrontation right in general and the history. So imagine you're setting up a system of criminal justice. You could try something like medieval courts with the ordeals, something like, well, okay, we'll brand somebody and we'll brand the defendant, and if the sore festers in 3 days, then we'll say that the person is guilty. The ordeals worked pretty well because they yielded a result. The problem was that it didn't really have anything to do with the truth, you know. So beginning in 1215, the Catholic Church said, you got to do something else. And what the English did, as many systems had done before, was rely on the testimony of witnesses. Actually, pretty much everybody since the ordeals has relied on the testimony of witnesses. People who observed what occurred and then relate what happened. So if you do that, you have to come up with rules for how witnesses give their testimony. In continental Europe, they would give their testimony behind closed door to some official who would take it down and then present it to the trier of fact. But the English took great pride in doing it differently. They took pride in doing it the way the ancient Hebrews had done it, the way the Romans did it, by having the witnesses testify face to face with the accused in open court. And as time went by, it was also subject to cross-examination by the accused or by a lawyer, and always under oath. And you see, for hundreds of years, it's a point of great pride among the English that this is the way we take testimony, confrontationally, face to face. It was a point of importance to the American colonists. It was something that they complained about at the time of the Revolution. All the early state constitutions put in a guarantee of confrontation between witness and accuser. Sometimes they use the term face-to-face, the idea that this is the way witnesses testify. And then when the Bill of Rights was adopted in the United States, it included the right of the accused to be confronted with the witnesses against him. Now, something curious happened then, and it's sort of a mystery, but over around the time of the confrontation, lawyers started getting into the act more than they had before. And they said, it's not just witnesses that we want to cross-examine, that we want to confront. Anybody who said anything that's going to be used against my client, and anybody who said anything where you're going to ask the jury to say, well, that person said it, and therefore it's true. That's what we call hearsay. And so there became this great big broad rule against hearsay. But it was so broad it had to have exceptions, and it became more whole than cheese. It's a very big blob, and when we teach evidence, we spend a lot of time on the rule against hearsay, and it's a mystery. And somehow the confrontation right got sort of swallowed in and rather muffled. And part of what happened was, it's important to recognize that the Bill of Rights itself was only a limitation on the federal government. It did not limit the states. And so the confrontation right didn't really matter. Anything the Supreme Court wanted to do with respect to a federal trial, it didn't need to rely on the Confrontation Clause. State courts could do their own thing. But little by little, the U.S. Supreme Court started saying that individual parts of the Bill of Rights are incorporated against the states by the 14th Amendment. And in 1965, they said that about the Confrontation Clause. But then, so now the Confrontation Right Clause mattered. It meant that the Supreme Court could say a state had violated the Confrontation Right. Very important. But they didn't know what it meant. And finally, in 2004, there's a decision called Crawford v. Washington, which is a transformative decision, which said what the Confrontation Clause is about is testimony. A person can't give testimony out of court without confronting the witness. Crawford involved somebody who made a statement in the police station house. And then that statement was used against the defendant. And the court said, that's no good. Okay. Crawford replaced an older system in which the court had just looked to see whether the statement was reliable, which was a very weak, iffy kind of jurisprudence. Here they said, if it's a testimonial statement, big question, what does testimonial mean? Then it can't be admitted. And Crawford's been very important. It's been very important for cases involving fresh accusations, which courts have been very lenient about letting in. It's been very important with respect to lab reports, which many courts have just let in without the lab analyst testifying. There's one big question that the court had ducked until this last year, and that's how does it apply with respect to children? Okay, and before Crawford, the Supreme Court had handled several cases involving children, but for the over a decade after Crawford, the Supreme Court stayed clear of it until the case of Ohio v. Clark decided just this last term. So Clark involved a 3-year-old child who came into preschool with some welts suggesting abuse. He was asked by the preschool staff what happened. He said D did it. D was his mother's boyfriend. D was ultimately convicted. And the statement by the little boy, referred to as LT, was instrumental in the conviction. He was It was really the only evidence, well, at least the principal evidence pointing to him. It was critical evidence in the conviction. And LT himself did not testify at trial. In fact, the trial judge ruled that he was not competent to testify at trial. And so the defendant said, I haven't had my chance to be confronted with this witness, and this witness is crucial. And ultimately, actually, he won in the Ohio Supreme Court, but ultimately the Supreme Court reversed. And it was interesting that the Supreme Court was actually unanimous in reversing. And what they, although it was sharply divided as to the rationale and and many of the details. But remember the buzzword that I said is the statement testimonial? And they said this statement was not testimonial. The statement by the 3-year-old was not testimonial. And in large part, it was because the 3-year-old just did not have the capacity to understand what was going on, the cognitive capacity to understand that what he was saying was likely to be used as proof at trial. Well, I think that's right, actually. I don't think that a child that young is capable of understanding the significance of those words. And there's, I think, to be a witness within the meaning of the confrontation right, I think somebody has to have an understanding of the word that's often used is solemnity, the solemnity of the occasion. You have to have an understanding that what I'm saying may lead people to take action, and that action may cause serious punishment to be visited on this other person. I don't think a very young child is capable of understanding that. Beyond that, there's another factor which a colleague of mine, Sherman Clark, has emphasized, and I always note it, and I'm not sure what to do about it, but I think it may have significance. And what Sherman emphasizes is the moral component to it. To what testifying is an ordeal. It should be an ordeal, because testifying against an accused is weighty stuff. And the question is, when should society impose upon a child the responsibility and the ordeal of being a witness against an accused? And it's not clear that it should happen with respect to very young children. Sherman would say he'd take it up to age 14, which is interesting. So in any event, the outcome of Ohio v. Clark is that at least very young children, the case court only decided the one case, but at least very young children are not witnesses for the purpose of the Confrontation Clause. That statement is not testimonial. But what happens then? If the outcome of Ohio v. Clark is that these statements are then simply admitted against the accused without the accused having any rights whatsoever, I think that's very unfortunate. Now, let me emphasize. I think that in a case like this, when LT says D did it, I think that's significant evidence. It could well be accurate. It's evidence that the jury ought to hear. It would be really unfortunate if that evidence weren't usable. At the same time, I think we have to recognize that it's not certain evidence. Now, it may be that LT doesn't have a motive to lie, but who knows what kind of prepping there was done beforehand? Who knows what the underlying circumstances were? And there's a good deal of evidence in that particular case, by the way, suggesting that LT was not the perpetrator, and it may well have been the child's mother. So we can't take it just because the child said it, it's got to be true, and the defendant has some rights. But the idea of having an attorney cross-examine the child, to me, doesn't make an awful lot of sense. I think when you have a very young child, I think that statement is not testimonial in nature. The child lacks the capacity to be a witness, and it doesn't work very well to think about our usual courtroom style of examination. Even if the child is put, as the Supreme Court has allowed, in some cases, even if the child is set into a different room, even if the child is only in contact with the accused by electronic means. I don't think the event that's going on is really a testimonial event. But I do think the defendant, the accused, ought to have some rights with respect to the child. I think the problem is that we're used to thinking, well, it's a child is a human, and we treat humans in a given way. And what we expect is that humans will come in and testify, except that in some cases will allow their out-of-court statements to come in. But that the way that we expect to challenge evidence coming from a human is by cross-examination in court. I don't think it's very good with respect to children. I don't think it's appropriate. I don't think it's constitutionally necessary. But I do think that the defendant should have some rights, and I think that we've got to think in terms of a whole different model. I think we've got to think about very young children the way we think about non-human sources of evidence. So if, for instance, the prosecution says this pistol yielded evidence against the accused would have a right to examine the pistol. And I think that, but you can't cross-examine a pistol. You can't cross-examine, say, a bloodhound, okay? It's not an attorney's job. It's, with a pistol, it's a ballistics expert's job. I think something comparable should happen with children. I think the defendant should have a right to examine the child through a qualified forensic examiner, presumably a psychologist, well-trained, operating under a court-approved protocol to make sure that there's no abuse of the child, but that the accused ought to be able to select an examiner who would be able to sit down with the child in a comfortable room, nobody else present, though people observing, perhaps by one-way mirrors, and make an assessment, and that should be under videotape. Now, as it usually happens, the child has been examined in many places by a qualified forensic examiner, but not one selected by the accused. This would be another examination. But I think we've got to remember that the defendant's rights are at stake as well. The defendant can be sentenced to a long term of imprisonment. I think in Clark, he got, I think it was 28 years, if I recall right. And what the accused says is, but I want to be able to assess whether this source of evidence is actually really as reliable as the prosecution is saying. So I think that examiner ought to be able to examine the child. The videotape would presumably be admissible evidence if either side thought it would be useful, and the examiner ought to be able to give an opinion in court guiding the jury as to whether there are reasons to disbelieve the child. So there's more to say, but why don't I quit there and leave it to Tom.
All right. You know, I get edgy sitting. I think I'm going to go ahead and stand if I can still see you guys. Move around a little bit more. Thanks so much to the organizers and to the wonderful turnout that we have today. Are you guys, most of you undergrads? Yeah? And are you in a particular class? Or just from all over?
Some of us are in the same class.
Yeah? What's the class?
Topics of American constitutional law.
Oh, okay. Okay, great. So have you covered the Confrontation Clause?
Our professor mentioned
Okay. Okay, great. Well, thank you for coming.
I
So
can ask if they're getting credit for attending, or if they require it. I'm not sure.
you're getting
I'm not
credit?
sure if that's what
So, because what I thought I'd do is talk a little bit just personally about my history and how I got into this issue, because when I was a law student, my best friend was from Brown, and a lot of people were semiotics majors. Do you still have semiotics as a major? And all of them ended up going to law school, which I won't say the reasons for that. But so in case you're thinking about law school, I can kind of give you an idea of my experiences and how I got into this area. I actually hated law school. But I became really interested in children and child development while I was still in school, and I started to cross-register and took psychology classes. And actually, my third-year paper, which was the closest we got to a dissertation in law school, you don't really write a dissertation, was on how suggestible kids are and how we should not believe their reports. And that was where I started out. But my first job as an attorney, I moved out to Los Angeles. I actually thought about corporate law and then ended up turning down a job in corporate law. I moved over and did dependency law. And dependency law are not criminal cases, but they're civil cases where the state removes children from their home because of abuse and neglect. And in LA County, it's the largest dependency court system in the world, people say, with over 30,000 children under the care of the juvenile court. And so that's how I basically got my experience in child abuse, in working on child abuse cases. Now, at the same time that I was a dependency attorney handling these typical cases of child abuse, which would be usually a girl that was maybe 8 to 11 accusing a mother's boyfriend of sexual abuse, or maybe a slightly younger child accusing a father or a mother of physical abuse, that was the typical case I was handling. At the same time, the McMartin trial was going on. Now, you guys have probably never even heard of the McMartin trial, and that's a good thing, I think, for many of us. But at the time, this was the largest prosecution ever in the history of the LA County District Attorney's Office, and I urge you to check out Ross Chait's book, where he goes back and explores, reading probably 100,000 pages of transcripts of that case. That was a case which was very unlike my cases, which was preschool children accusing daycare operators of severe, ritualistic, oftentimes bizarre allegations of sexual abuse. So very different experience I had than the kinds of cases that the criminal court was handling. Very different experience than what appeared in the media and the kinds of cases that influenced a generation of researchers looking into children's suggestibility. Okay, so while that went on, I was arguing about what should happen in dependency court. Okay? And my experience taught me that my law school paper, where I criticized children as being unbelievable, had taken an unduly narrow look at the issues. First of all, it was clear that there are very few cases of preschool children. But because of McMartin and other cases like it, the vast majority of research on suggestibility is on preschool children. And when there were preschool cases, and cases where they would come into our court, one typically could find reasons to doubt the credibility of the allegations. So there would be a parent who was extremely supportive of the allegations. Most of these cases came to us from family law. So it would be a mother who might be accusing an ex-husband of abuse, or an ex-husband accusing a mother's boyfriend of abuse. And so one could look at these cases and without thinking too deeply say, I think there might be some suggestive influences at work here. The typical cases, however, that I was handling were older children and parents who were not so supportive. And recently, in work that I've done since becoming a professor, we've quantified this. So we took a look at 250 cases going through the dependency court system in children accusing people of sex abuse, and we found that 25% of the time, the child will recant the abuse allegation at some point. We found that if the child was under 10, if the mother wasn't supportive, and if the child was alleging abuse against a household member, then over 50% would recant their allegation at some point. And so I began to see that the primary problem that we faced in dealing with child abuse was not an issue of false allegations, but was more an issue of false denials. Now, more recently, I've looked to see, well, what actually goes on in a typical criminal case? Because I had seen McMartin in the newspapers. I'd actually gone up and watched McMartin, but I thought, is McMartin a typical case? And recently, we did a study where we looked at 5 years of prosecution of sex abuse cases of children under 14. Again, we found virtually no preschool children. I think there were maybe 3 or 4 kids who were as young as 4 or 5. Most of them were totally incapable of answering questions once they took the stand. So they were found incompetent, but they were found incompetent because they wouldn't even answer questions in court. And only 3% of the cases were cases where the prosecutor didn't try to produce a child witness. Only 3% of the cases. So basically, none of these cases looked like the preschool cases, and none of these cases looked like the case in Clark, where the prosecutor didn't even produce the child. Now, even when the parents were supportive, children's reports were often less convincing because they didn't report the abuse until long after it began. And since those cases, I've read a large literature on the modus operandi of perpetrators, right? What do sexual abuse perpetrators do? Well, we know that they identify vulnerable children who seek affection. They give them attention, presence, special privileges. They start with non-sexual touching and they build up to more severe abuse. And once abuse has begun, they use a combination of threats to keep children silent. If they're a parent, they can take advantage of the naturally positive feelings and protectiveness that children feel towards them. So it's really very easy to understand why children will delay reporting, and then even once they do report, will frequently recant their abuse allegations. Now, of course, Clark was a case of physical abuse, not sex abuse. Although I should tell you, when we argue about child witnesses, most of the cases are sex abuse cases. Second most often are physical abuse. Third most often are cases where children see parents fighting or fathers typically killing mothers. But in physical abuse, many of the same dynamics operate. Physical abuse tends to be born of excessive discipline, and children are naturally ashamed to acknowledge it because they feel partially responsible. And by the same token, sexually abused children feel partially responsible because of the progressive nature of sexual abuse. After working as a dependency lawyer for several years, I went back to school in developmental psychology because it became clear to me that developmental psychology had a lot to say about how we ought to be questioning kids. And what I did in graduate school is studied preschool children's emerging understanding of concepts such as remembering and forgetting. So the arguments that Professor Friedman makes with respect to what children can understand at a very young age is something that I'm very familiar with. Now, when I finished graduate school in psychology, I got back into legal issues because of a California appellate court case that said that if a child was testimonially incompetent, and this is a standard that many states use and that was used in Clark, if the child didn't seem to understand the difference between truth and lies, then the child's hearsay should not be admissible. So it would be like in Clark, the child doesn't qualify to testify, and then the court would go on to say, and because the child doesn't qualify, we're not going to let the child's out-of-court statements be admitted. Well, it seemed clear to me at that time, and this was back in the 90s, that developmental psychology could help in assessing whether young children understand, and in determining whether a child's understanding of truth and lies really matter, right? Does it really affect the likelihood that the child is going to tell the truth? And what we showed, and this I've probably done way too many studies on this topic, but I'll just tell you about one study, is that children's apparent understanding is highly dependent on the way in which the questions are asked. So for example, if you ask a child, what would happen if you told a lie to the judge, they are more likely to say nothing than if you ask them what would happen if this boy told a lie, and you just show them a picture of a boy. Now, the reason is not that they think they're invulnerable, that would be one interpretation of the results. The reason is that very young children, and this would be children who are preschool age, will interpret hypothetical questions as suggestions, and they simply reject the premises. So what kids do is kids say, but I'm not going to tell a lie, right? And so nothing will happen to me if I lie, right? So they reject the premise of a hypothetical. Now, ironically, they think very seriously about the consequences of lying, but because of that, they appear incompetent to courts who question them. And we also show that children are more likely to promise to tell the truth if they promise to tell the truth. And then this is really interesting. They are more likely to tell the truth if they promise to tell the truth, even if they don't appear to understand what the truth means, given the tasks that we've been able to develop. And so what that suggests is even with very sensitive tasks, we don't get at what kids really understand. Okay, so hopefully I've given you a sense of sort of the way that my experience in the law has taught me what typical abuse cases look like, and what my work in psychology has taught me about the fact that we underestimate children's abilities. So what about Crawford? So Crawford was very exciting for all us evidence professors who are typically ignored by the Supreme Court. And it was exciting for me, but perhaps in a negative way. So when Crawford first came out, it was clear to me that it would have negative implications for any case in which a victim is initially cooperative, but then who refuses to testify, right? And this is most apparent for domestic violence victims, but also victims of child abuse. Because if someone calls the police and tells the police, that is more likely to be a testimonial statement. And if they never show up at trial, they can't be cross-examined. And if they can't be cross-examined, the testimonial hearsay will be excluded. So you see how it hurts domestic violence prosecutions, hurts child abuse prosecutions. Now in Clark, I got involved in a very early stage, and this was, I think, quite lucky for me. I'd been writing amicus briefs and submitting them to the Supreme Court, but they were in cases, as Professor Friedman explained, that didn't have anything to do with kids, because they weren't accepting review of cases with kids. So we would say, hey, think about how this case might apply to kids. And of course, they would totally ignore our arguments in their opinion. Now in Clark, however, we were involved at a very early stage. We were involved at the stage where the case wasn't even accepted by the Supreme Court. So the case was in the Ohio Supreme Court, And the state of Ohio asked the American Professional Society on the Abuse of Children to weigh in on this case. And so we helped them ask the court for review. And this is, and it's incredibly rare. I think maybe it's less than 1% or 1/10 of 1% of petitions for cert that are accepted for review. Yeah. So it was pretty amazing to us when the court accepted the case. Now, when you're asking the Supreme Court to review a case, part of your job is to convince them that the lower courts are divided. And it's interesting, because Ohio thought, no, we just got to convince them that Ohio has made a mistake. And the lawyers I was working with were very patient, said, no, you have to actually get them to think that the lower courts don't know what they're doing, not that they're just wrong in this single case. So we made two arguments that we thought divided the lower courts. The first question was whether statements made to mandatory reporters are testimonial. Okay? Now, this is, I guess, sort of the putative topic for our debate today. So let me say a little bit more about this. So you know what mandated reporting is, right? So teachers are mandated to report child abuse. That's the law. And on the one hand, you can say that when you become a mandated reporter, you're being deputized by the police to do the work for them, right? And if that's true, if you're being deputized by the police, then anything you elicit from a child would be testimonial hearsay. And the court had suggested in Davis, and I think the case that you argued before the Supreme Court was Davis and Hammond. So the court in Davis said that 911 operators are essentially agents of the police. And the Ohio Supreme Court had relied heavily on this notion, the agency relationship, to argue that teachers were like cops, basically. On the other hand, however, being a mandated reporter doesn't mean that you're no longer doing your job, and your primary purpose is what your job is. If you're a teacher, if you're a doctor. And many courts had held that children's statements to doctors were not testimonial, because although they were mandated to report abuse, their, quote, first and paramount duty, unquote, was to provide, say, medical assistance. So courts were not applying this rule to doctors eliciting statements of abuse from children. And what the Supreme Court ultimately had done, had spoken in terms of whether the primary purpose of the interrogation was to collect evidence in anticipation of prosecution. Okay, now what we argued in our brief, we said, okay, the lower courts have generally recognized that this is not the primary purpose of doctors. And I think part of this had to do with the well-accepted medical diagnosis exceptions. The court said, well, we can fit it into that hearsay exception. So we'll say doctors are not agents of the police. But what we argued is that social workers and teachers, in this case, could have a primary purpose of protecting children rather than assisting prosecution. And we elaborated on this argument in the next stage. So I'll come back to that. The second thing that we saw some division among the lower courts had to do with whether the age of the child matters in determining the primary purpose. Now here the difference among the lower courts was very clear. Some said that it was important to consider how old the child was, and as Professor Friedman has said, he feels that that's extremely important in understanding how much the child understands the purpose of the questioning. But some courts have said it was irrelevant. So I'll give you an example of the kind of case that gets overturned in this environment. In Seiler, this is an Ohio Supreme Court case, a murder conviction was overturned in which a 3-year-old had reported seeing his father beat and then hang his mother in the garage. In response to police detectives' questions, the child stated his mother was sleeping standing in the garage, was the way he described it. He explained how Daddy, Mommy fighting had scared him. And when asked if anyone was hurting Mommy, he said, Daddy did. The child told the detective that the yellow thing had held his mother upright in the garage, and asked who put the yellow thing on her. He responded, Daddy. He was describing a yellow rope that had been tied around her neck when his father hung her. And the court stated that the age of the child was irrelevant in determining if the statements were testimonial, because the child was questioned by the police, and the police were clearly anticipating prosecution, and therefore the child's statements were testimonial. Now, whether children's age matters depends on two different things. First of all, what children think they are doing when they respond to questions by different adults. Right? What does the child think is happening? And what adults think they're doing when they question children at different ages. And I'm going to come back to that too. Okay, so that was our petition. So we said we were writing an amicus brief, we were supporting a petition for review. Supreme Court takes review and we're like, oh my gosh, this is amazing. We can actually influence the court in terms of its views on kids. And as Richard mentioned, Professor Friedman mentioned, the court had rejected review in every case involving children up to this point. Okay, here's what the Supreme Court decided. First of all, the court said this was an ongoing emergency. Now, this surprised me because the child was not in any imminent harm. The child was at school. He was safe and sound in the care of the school. And the court in Hammond, and this was the case that Professor Friedman successfully argued, had said that if a perpetrator is separated from a victim, even if he's in the same house and he keeps trying to get into the room with the victim, then there's no emergency. And Scalia in his concurrence, and Scalia is the architect behind this, the judge who wrote Crawford and who's been the foremost proponent of keeping it alive, explained that the purpose was to protect the victim from future attacks and to make sure that they didn't deliver an abused child back into imminent harm. And so the court here hints at a very important difference between children and adults, right? Now, I thought it was wrong when the court said in Davis, and the court said this in Davis, that as soon as the domestic violence perpetrator leaves, the woman is in no danger, no emergency. But what occurs to me is that what I think the court was saying is that because if the perpetrator comes back, she can call the police again, right? That's why we can say the emergency is ended as soon as the perpetrator has left the premises. But a child can't do that. So it's an emergency as long as the child is in a situation where the state may have to release that child to the perpetrator unless they can get credible evidence that allows them to protect the child. And this, I think, is a very important point that will be useful in the future. Now, we spent a lot of time in our brief arguing about how there are two different systems for intervening in child abuse and neglect cases: protective services and police, and how mandated reporting was primarily aimed at protecting children from future harm. The court pointedly said that it didn't matter what the teachers thought would happen when they called, meaning that it didn't matter that they thought social services or the police would arrest the perpetrator. And Scalia went out of his way to note that the same rule would apply to police questioning. Okay, so in some ways the court was going farther than we thought they would. But the court did say that it mattered whether the person questioning the child was, quote, principally charged with uncovering and prosecuting criminal behavior. Basically, if you're a cop. And if you're not a cop, then the court considers that highly significant. The second thing the court emphasized, and then I'll conclude, is that the child's purpose was not to produce evidence to be used to prosecute the perpetrator. Now, this sounds a lot like Professor Friedman's argument, but we differ greatly in this. He thinks that 4-year-olds can't be witnesses, and they aren't witnesses because they're not capable of accusing or of understanding their accusations. What we said in the brief, though, and what the court quoted in its opinion, was that children don't understand. It's not that they're incapable, it's that they don't know what will happen when they talk to a social worker, or when they talk to a teacher, or when they talk to a parent. Children do understand that if they tell a policeman that someone has done something bad, the policeman can arrest that person. And for that reason, we argued that in limited cases where the child is talking to a uniformed police officer, the child probably does recognize the consequences of his or her statements. Even the youngest children have some understanding of the police. Okay? The court was very clear in that it didn't think it was an incapacity, but it felt it was a lack of understanding. The court emphasized that the teachers didn't tell the child why they were asking the child those questions, and that the child didn't indicate that he thought that the police were going to be called. And we also argued, and the court also accepted, although they didn't cite us on this point, that the reason why children complain of abuse is not because they want people prosecuted, right? They accuse people of abuse who they love, who are close to them, who have seduced them in many ways into loving them. Children disclose abuse because they want it to stop. And if that's their motivation, then their statement should not be considered testimonial. And we've cited lots of research on this point. Okay, so let me just take one more minute. What does this mean for the future? What I think we should do is encourage further development of what's called the Child Advocacy Center model. In this model, and this is what most states have adopted, I think it's fair to say. I know it's true in Los Angeles County, and Ross can tell you if it's true in Providence. Children are referred for a videotaped, structured interview immediately after their first disclosure. Specially trained interviewers conduct the interviews, and different professionals can watch but don't participate in the interview. And the interviewer follows a protocol which tests alternative possibilities for how to explain the child's report. These should not be considered testimonial, in my view. The child is not told that this is evidence for prosecution. The child's motive is not for prosecution. This is formal, and the court has often said that formality means it's testimonial. But I think that should be understood in terms of understanding the perspective of the declarant, understanding the perspective of the speaker. Formality connotes a prosecutorial intent because the person who's being questioned recognizes when they sign an affidavit that it's going to be used. But even a child won't even understand that. The state is primarily interested in protection. Most cases of abuse are never prosecuted, and has a secondary interest in supporting the child's testimony, but not in replacing the child's testimony at trial. Videotaping means we have a complete record. The framers had no idea that videotaping could exist. So when they worried about government producing witnesses behind closed doors, you're videotaping the interaction. You know what the questions are. You know what the answers are. The tape can be made available to the defense, who can show it to their expert. And the child can be asked to testify if the defense insists on it at trial. Now, this is a very different approach. Finally, as a practical matter, prosecutors still will attempt to bring a child to court because of juror expectations, and the defense can use compulsory processes. You've learned about the compulsory process clause, to bring children to court when they insist on it. However, I think we should have a strong rule of forfeiture. A rule of forfeiture says that if the defendant reasonably anticipated that the child would not be able to testify, and can show this through the process of seduction that I've described with sexual abuse, then the defense cannot complain of unavailability. Okay, now I think I probably said too much at this point. So I have some thoughts about how my proposal differs from Professor Friedman's, but I guess we can save that for our little back and forth.
Okay. Well, yeah, we do disagree on some things, but it's interesting how I think the Clark case has forced us or pushed us together to some extent. So let me take up the Seiler case, which Tom mentioned. This very sad case of the 3-year-old who said something about the cord. I think it would be bizarre to say, okay, we've got to bring that child in to be cross-examined in court. And yet the evidence is clearly extremely significant. Now, it could be that something was wrong, that the child got something wrong. But I think the Ohio Supreme Court got it wrong in saying that was testimonial, even though he was talking to a cop. If you make that a 15-year-old child, it's very, very different. Now, the police officer's intent in having that conversation is the same throughout. I think, and similarly, if we imagine the exact same facts pretty much as in Clark, except make it a 15-year-old or make it an adult who's talking to a school supervisor or to a social worker or whatever, it looks very different. So what I'm saying is I think that the fact that the police are trying to get evidence doesn't matter with respect to the confrontation right, I don't think. What matters is the perspective of the speaker. Is that person engaged in an act of witnessing? Now, if that person understands that that the audience, if say the child or the victim, whatever, understands that the audience, the person to whom he or she is speaking, is likely to use that information in the prosecution of a crime, that's what makes the act witnessing. And so the child, adolescent, adult, whatever, that person's understanding of the function performed by that other person is crucial. But I don't think that no matter how much the cops are trying to get evidence, makes it testimonial. So I think the whole issue of a mandated reporter, we've got to look. Being a mandated reporter doesn't make it testimonial. But if an adult is speaking to a social worker and describes a crime, and everybody in the room understands that social worker is going to pass it on to the police, and if that statement is then used in a prosecution, then what we've done is created a system in which you can testify by talking to a social worker, and you don't have to come to court. And that I think violates the confrontation right. So now I don't think there's anything in the Clark decision that says anything to the contrary of that. I guess I didn't read Clark as saying that this was an emergency, but I haven't looked at the decision in a while. Maybe you have particular language. They definitely were saying that the school teachers had other purposes for having the conversation. And that's true, of course, but I think if the focus is kept on the speaker, what does a person in the position of the speaker understand? Then we get to a much clearer, better sense of what the right is. And I don't know. I mean, I know far less about the psychological literature than Tom does. As Tom knows, I've been working with Steve Ceci, who's a very noted child development scholar, with whom Tom has often disagreed. And we put in a friend of court brief ourselves in Clark talking about this. And Steve's view is that very young children don't have the understanding, the depth of understanding to understand the full process of witnessing, because it is a long and complicated process of inference, that if I say this, make this statement to this person, then a whole row of consequences is going to follow. With respect to the Child Advocacy Center model, I think that's great as far as it goes. Sure, why not? But if I'm a criminal defendant, I still say, wait a second, don't just give me the tape. I want to be able to examine that witness. I'm sorry, that child. I don't think it's a witness. I have to be able to ask questions myself to make my evaluation. Don't tell me that there are government agents or neutral agents who are doing it, and that's good enough. Justice Scalia said in one of the decisions that the framers would have been astonished to learn that our rights had been given over to determination by neutral government officers. Whether the Child Advocacy Center is a government agency or is a private agency that's funded by the government or whatever the source of funding is, there's no doubt that it's going to be dealing, that the prosecution is going to be a repeat player that is always before it. If I were a defendant, I would say, gee, I don't think they're neutral, and neutrality isn't good enough. So fine, have that examination, but let me do something as well under tightly controlled circumstances. One other point on forfeiture, which is an interesting one, and it's been an interest of both Tom and me. The basic idea of forfeiture is that you can do something wrong and therefore give up the confrontation right. The clearest example is the person who kills a witness. Okay, the definition of chutzpah is chutzpah is the quality demonstrated by the person who kills both parents and then begs for mercy as an orphan. Okay, so there's another type of chutzpah which is pretty close, which is the person who does something wrong, such as killing the witness, and then says, but you can't use that person's statement against me. I didn't have a chance to cross-examine. Well, wait a second. Why don't you have a chance to cross-examine? You killed him. Okay? You murdered that person. So that would be an example of forfeiture of the confrontation right. And I've argued for a very broad conception of forfeiture, and I thought I was the broadest person out there in terms of the breadth of forfeiture that I would see. And I've got no trouble with seeing, even with respect to children who are capable of being witnesses, that if the defendant's own conduct intimidates the child and renders that child unable to testify, that should constitute a forfeiture. I think that before we conclude forfeiture, I think that the effort should be made to get the child to testify. I'm talking about older children who are capable of testifying. Tom goes a little bit further, I think, just a little bit, because I think that you can only forfeit when you've created the inability to testify. Tom would say that if, as I understand it, even if the defendant takes advantage of the inability to testify and picks that person as a victim, that to me is going too far. That's saying, well, you committed the type of crime that was difficult to prove, and therefore we're going to take away your rights. And I don't think that's appropriate. But in reality, I don't think the practical difference between us on that is very large. So that's all I have to say for right now.
Okay. Yeah, so I guess the main difference I see between us is, it seems to me like you're trying to wall off children because you recognize that we need to treat this class of victims differently, and the implications are worrisome if we start to understand victims better. And what I mean by that is that, as we start to understand the fact that cross-examination doesn't work, victims report crimes not because they want prosecution, but because they want protection. Police are as invested in protection as they are in arresting and prosecuting offenders. Then we might have to start to think differently as we move back out to the adult victims, or as we move to, say, sexual assault victims, who tend to be, actually they usually tend to be teenagers, but tend to be young adults. And that if we recognize these problems that exist with kids, and then we transfer them over to adults, we realize that the whole structure by which you insist upon a cross-examination right at trial starts to sound less and less favorable, less and less beneficial, certainly less beneficial to truth. And so these are the kinds of questions I would have. I mean, first of all, it's that both you and Professor Ceci talk a lot about how cross-examination doesn't work with kids, but you don't confront the issue of whether cross-examination works with adults. I don't know of any evidence that cross-examination is an effective way by which we get truth. You say that it doesn't seem fair that the defendant doesn't have some rights to confront the non-testimonial child, but by that token, we should allow the defendant to confront other non-testimonial witnesses. And so one could construct an argument, and this is an argument that would be analogous to the argument you make with respect to kids. You say, well, kids don't make testimonial statements, and that's unfair because then they don't testify. But of course, there are lots of non-testimonial statements where the person doesn't have to testify that have been accepted by the court. So someone calls for help, and when it's really truly a call for help, and it's before the police move in to arrest the perpetrator, that call for help could be admitted at trial, and that person would never have to testify. Well, someone could say, well, how do we know that calls for help are reliable, right? It's based on this ancient theory that has been totally discredited by psychologists, that when you're super excited after some traumatic event, you cannot tell a lie. The theory is, it's called, it stills the reflective ability to tell a lie. Well, that's just absurd, right? So if I was a defense attorney, I'd say, look, in any case where someone has a call for help, they're super excited, their perceptions are distorted, their narration is distorted, and narration is the term that we use in evidence for when someone speaks and you're not really sure whether what they're saying is what they mean to say. These are all reasons why this person should be brought in and should be forced to testify. But then the defense can say, okay, but we understand that it's hard to evaluate people because cross-examination isn't the most effective tool, so I should have a right to subject all of these non-testimonial witnesses to a polygraph test. I'm going to hire an expert, and the expert's going to give the person a polygraph test, and then the expert's going to come into court and tell us if the person is lying or not. Now, that may seem absurd to you because you'd say, well, polygraphs are notoriously terrible. But actually, the evidence is quite good that polygraphs are as good as jurors are in assessing testimonial truth, right? Jurors are terrible at telling whether people are lying or not. That just seems absurd, right? But it doesn't seem absurd when we say, oh, these little kids, they're different, they have no comprehension, they have no understanding. And so I think what I worry about is that we treat kids as if they're totally different animals. In fact, you say this, you say they're not even really human in a way.
No, wait a second. I'm sorry to interrupt. I've never, ever said that they're not really human in a way, and that's just a distortion. I've never suggested that. I happen to have 3 kids, and they're all human people.
Right. Well, I'm sorry. I don't mean to be provocative,
Well,
but
no,
you made the argument.
that's just a distortion. I've never said they're not human in a way. Of course they're human.
But
I said that we shouldn't treat them the way I said that we shouldn't have one set of rules for all human witnesses. That's a different. I said that for all human makers of statements that it shouldn't be humans versus non-humans. That's a very different thing. That just saying, oh, you're a human person and you made a statement that's being used and therefore you're subject to the same system. That I don't think makes sense.
Right.
Of course they're
Right.
human. I've never said anything different.
yeah. Well, I'm thinking of your argument that the child is akin to the bloodhound who barks.
I'm sorry. To
Yeah, no,
interrupt.
I'm
said-
happy to
but,
hear your
is this
thoughts.
all right? I said we should treat the child the same way. Do I think a child is a human being? Of course, I think a child is a human being. Do I think a
Right.
child is a dog? No, I don't think a child is a dog.
Right.
But the question is, how do we treat the statement by a child? And I don't think that treating the statement by a child the way we treat a statement by an adult is an appropriate way of handling it.
Right. Right. Yeah.
That's
No.
that's a very different matter.
I'm happy with that. So my point is that why don't we treat children as much like adults as we're capable of doing so, and recognize that the problem is not with the child's level or capacity, but with our ability to meet the child at their level of ability. So rather than shift from a system where we bring witnesses into court and we ask them questions designed to test whether they're telling the truth, why do we give that over to experts? And actually, that's something we want to talk about, is who are these experts? What do they believe? What sort of things are they going to say? Why are we letting them tell the jury whether the witness is telling the truth or not when we don't let witnesses tell the jury that other witnesses are telling the truth? Why do we do that rather than say, okay, let's accommodate? Because what the court has tried to do, and I think it's fair to say you've resisted this, what the court has tried to do is to say in certain cases we can allow children to testify without the defendant present. In certain cases we can regulate the kind of cross-examination that defense attorneys are allowed to ask. I think an interesting model, although it's very experimental and it would take some time to develop, is I could see allowing the defense attorney to question the child, but only allow it through an intermediary. And the argument would be, you might say people who speak Spanish are not good witnesses because we ask them all these questions and they keep looking at us and they keep saying, I don't understand, no comprende, right? And someone says, well, hey, this person is speaking Spanish, we need to bring in a translator. And the defense attorney will say, well, I got a translator. And you say, no, we should have a court-certified translator who comes into court and tells us what the questions are. Now, ironically, it turns out that Spanish interpreters soften the questions that defense attorneys ask, and that creates a little bit of a stir. But it's basically a model that, we're going to keep the same system. We have a child who's basically, in many ways, as capable as an adult, but only if we treat them in the right way. And then we allow the defense attorney to ask questions, but only through an intermediary. And so my argument basically is that I think it's wrong to wall off children in this way, and I think it's particularly wrong to wall them off and then turn them over to experts who I don't trust. And we can talk more about why I don't trust them.
So,
Okay, so I wanted rebuttals, which you don't normally have, to bring out disagreement. I think it worked.
Too well.
No, I think it worked. And if you'd like another minute right now.
Yeah, sure. Okay, one thing is, your proposal treats children differently because you have the center and you're willing to allow the videotape to come in and that would be evidence. And you say, well, the defendant can bring the child in if they want to, but the prosecution wouldn't have to. Now, unless you're saying that we should replace the entire common law trial the way we've been doing it for 500 years by having that system with respect to adults, you're also going to treat children differently. You say cross. I don't know. It's a valid point. There's no proof that cross-examination works in the sense. I mean, courts keep saying it's the greatest engine for the determination of truth, and has that been empirically tested very well? No. So far as I know, it hasn't been. But it's something that has been considered crucial to a sense of justice. For the idea that you say that to me face to face has been crucial for millennia, actually. And I think sometimes it does work, whether it's got a good percentage or not. I mean, sometimes it brings out, it forces the witness to, it exposes the frailties in the testimony. So I mean, I think at times it clearly does. I had trouble following when you said non-testimonial witnesses, because that to me is a contradiction in terms. Witnesses are those who give testimony, and that's the point of the Confrontation Clause, is that those who testify should do it in court. I do think that very young children are different with respect to cross-examination. It's not simply a matter of the effectiveness, but the basic idea of cross-examination is very often is, you've said X, you've said Y. X and Y can't be both true, so what's going on? You can't begin to get that kind of traction with a very young child. So I think it's important to hear from children. I think it's really crucial. But yeah, we do have to recognize the differences, and we have to provide some protection for the defendant.
Okay, I want to have I want to get questions. We'll go to you first. So, questions?
Should we stand?
Yes. You want to?
Yeah, hi, thanks very much. I think this is very interesting. So I guess I have kind of two connected questions. The first is, it seems like a lot of this problem turns on the worry that children will be traumatized by seeing their abuser in court or being questioned by the agent of the abuser. And that's certainly plausible, but it's not obvious. So do we have some research that tells us just how bad it is, how damaging it is for a child in those circumstances? And then two, if we could kind of get past that, if that weren't a worry, if we could have some sort of decorum where we weren't harming the witness, why couldn't we just have the child testify and then have some system for telling the jury, look, judge's instructions or something, you've received the testimony of a child, it differs from adult testimony in these important ways, keep that in mind in your deliberations.
So let me start with Tom.
Yeah, so there is research. And so when you ask children, what's the scariest thing or what's the worst thing about going to court, they say having to see the defendant. And there's some research that courtroom testimony can be traumatic, but it depends. And it depends largely on what the outcome is, which makes it tough, because you don't know what the outcome's going to be. But when an acquittal occurs, you tend to see worse results for children down the line in terms of their mental health. But, I actually don't think in terms of the trauma to the child. I think in terms of that children are incapable of testifying in many cases if they're forced to confront the accused. And if a child's statements are considered testimonial hearsay, or if the child's presence is required, then that will lead to acquittal in a large percentage of cases. Partly as a matter of law, but also partly the jurors expect to see the victim to come into court. And so that's where I see the problem of forcing children to confront their accuser, the accused comes in. I recognize that there may be trauma. I think we can reduce the trauma through, there's now some work being done with support dogs, where you can bring a dog in that the child has gotten to know and that lies at the child's feet and that keeps the child calm, right? I think these intermediaries can reduce the stressfulness of the cross-examination and the kinds of questions that are being asked. The prosecutor can stand between the child and the perpetrator, so the child doesn't have to look, or the defendant, I should say, the child doesn't have to look at the defendant. So I don't see the traumatic effects of the courtroom as being something that should drive us away from allowing children to testify. I'll stop there.
So I agree in significant part. I mean, I think the biggest problem is what I refer to as the clamming up part. I mean, you say to the kid, okay, you're going to testify, and then, the kid just can't do it. or won't or whatever. And then also the way our criminal justice system works, unfortunately, is very often by the time you get to trial, it's so long ago. It's very hard to ask the kid, tell us what happened. And then when you get to the extra layer of logical complexity, now a few hours ago you told Mr. Prosecutor such and such, now I want to ask you about it, it becomes very difficult. So that's the unfortunate thing that even if you say, well, the kid has a sense of obligation to tell the truth, whatever, some kids just aren't going to be able to do it. And yes, I mean, my understanding of the research is that the scariest thing is confronting the accused. There's some research that's suggesting that in some cases it can be cathartic, that once the kid gets through it, it can be cathartic. There is research indicating that after a period of months, there's recovery. Something I saw suggested that after 7-9 months, the psychological difference between those who had recovered and those who testified in front of the accused and those who hadn't was indistinguishable. I mean, that makes for an unpleasant time. Most prosecutors will say that with sufficient preparation, they think that they can make it much easier for the child to bring the child into the courtroom, explain what's happening. Now we're talking about children of sufficient age that they have some understanding, and most prosecutors would rather have the child tell the story if the child's able to do it than rely on secondhand evidence if that's all they've got. I'll go back to what I said about the testifying is an ordeal. It should be an it should be an ordeal, but there's sort of like an optimal level of ordeal, I think. I mean, we don't want it to be too great, and that's the difficulty. That sort of goes back to my colleague Sherman Clark's question about at what stage do we want to impose that ordeal on kids.
Another question? John?
Could you tell us, for both of you, I'm interested to hear what you think about the path of the law with respect to the Confrontation Clause from Crawford to Clark. So with Crawford, we have this, I gather, very strong affirmation of a confrontation right. Do you see Clark, and the Clark was 9-0, but as I understand, the opinions were divided, people were divided on the reasons.
Yeah.
I'm interested to hear how you read what the judges' lineups were and the reasoning, but more generally, do you think that the confrontation right was weakened with Clark? Do you see that it's not a weakening, but just a application in another area? How do you see the Confrontation Clause after Clark?
Should
Yeah.
so take that, yeah. Crawford was a very dramatic decision, as you suggest. Justice Scalia, when asked which is his favorite of his opinions, it was Scalia who wrote it, said Crawford. And it was a remarkable opinion and a remarkable decision in many ways. One point about it that was remarkable was that it got support both from the left and the right of the court. The only justices who didn't join in it were Rehnquist and O'Connor, who were sort of pragmatic conservatives and not the left end of the court and not the right end sort of principles justices. And because Crawford made this very dramatic assertion that if a statement is testimonial, it can't be admitted against an accused to prove the truth of what it asserted, assuming that the witness doesn't testify at some point subject to confrontation, cross-examination. Very, very different approach from anything that had happened before, or at least in the recent past, when this court had sort of said, well, if it looks reliable to us, good enough. And I think it went so much against the grain of what lawyers had gotten used to over the last half century or so, that the court began to lose its nerve. And 4 justices have been out to undercut it, for the last 7 years or so. And it's interesting. The 4 are, it's not a left-right split again. I mean, 3 of them are from the right. I'm talking about Alito, Kennedy, Roberts, and Breyer. Yeah, I think...
Did you say why what worries them about it so much?
Well, I think again, it's a principles versus pragmatism type of thing, and I think they're worried that it's just going to be harder to prove crimes. You know, my own view is that if the court really stuck to it, it would be it's actually very it's very practical in every setting. Including lab tests, including fresh accusations. I mean, there's some things that the courts have gotten sloppy with. There's no doubt. But I think those four tend to be justices who are less willing to make the thunderous pronouncements, you know, that say Scalia and Thomas are on the right, and even perhaps to some extent Kagan, Sotomayor, and Ginsburg. But they've looked at some of the cases and said, oh my goodness, you mean you're going to make a lab witness come in, a lab analyst come in and testify? You know, in every case where lab results are produced. And no matter how much we say, well, you know what, usually it doesn't happen. Usually the defendant doesn't insist on that. When they do, there's not a whole parade of witnesses. It's really very pragmatic. There are states that do this, and they haven't collapsed for this account. They don't seem to care. They just seem to be very worried about the effect. So Alito is one of those who has just been out to undercut Crawford ever since he got into court, I think, really. And so yeah, there's language in there that does tend to undercut it. I thought Scalia in his separate concurrence went a little bit overboard. I mean, Scalia has a way of seeing a majority opinion that he doesn't like, and he says, "Oh my God, the sky is falling. This is the end of the world," which tends to make it happen because then the next case they said, "Well, see what Scalia said about that," you know. So yeah, I think it's a dramatic new way of thinking about things that they're just not entirely ready to accept, which is unfortunate. Because it's pretty clear, straightforward, and simple. If you make a statement with the understanding that it's likely to be used in prosecution, that's a rough definition, that's testimonial. You got to come in and testify before the accused. If you're unavailable, but the accused had an opportunity to cross-examine before, good enough. And if the accused engaged in substantial wrongdoing that rendered the witness unavailable, then the confrontation right is forfeited. I'm not standing on one leg, but I could have said all that while standing on one leg. It's pretty simple. It's very practical, and I wish they would do it.
But you didn't say how much. Do you really think Clark undercuts that a lot?
Hard to know. I mean, it's a child case, and we'll have to see. You know. We'll have to see to what extent it's the language is used beyond the context of children. Yeah.
Tom?
Yeah, I think it could, well, especially because, as Richard mentions, that so many people in the court want to limit Crawford, so I think it could have that effect. And there are a couple ways in which this is true. I mean, one way I read Clark is that it seems to be saying that the declarant must have testimonial purpose or testimonial understanding. In other words, the person who makes the statement must understand that there's anticipation of its use in prosecution. And then the fact that a young child doesn't have that understanding means it's not testimonial. And if the court is moving in that direction, then it solves one interesting puzzle, and that is, what if the state deliberately and methodically sets up a person so that they're speaking to a police informant who records the conversation? And so the state is clearly trying to create evidence for prosecution, but the person is totally unwitting. And the court has hinted that that's not testimonial.
Shouldn't be.
But they've never held it. And every circuit court that's looked at it has said that's not testimonial. But you realize what you get into in that situation is where the state is clearly trying to manufacture evidence, but it's not being treated as a problem for the confrontation clause. So I think that's one interesting way that Clark will keep us moving in that direction. So I guess, so you think the declarant's perspective is necessary
Oh, I've always said that it's entirely the declarant's perspective, and the court has gone off balance, and this is the case Michigan v. Bryant, which we haven't mentioned, where they said take into account, it's a combination. I mean, it was a very uncertain type of thing by Sotomayor of both perspectives. I think it's the
Right.
declarant's perspective, taking into account the entire context.
Yeah.
In fact, I'll say I was second chair at the argument of Crawford, which is a very uncomfortable position to be, particularly for a law professor, because it meant that I was about as far from Jeff Fisher, who argued the case, as I am from Tom right now, and I couldn't say a word. And that's really difficult. And this is stuff I cared about a lot. And the question came up, precisely that. How is this going to work with statements to undercover police officers? And I think Jeff had some trouble with the decision, with that question, but then Breyer jumped in and he said the law professor's brief, that was one I had written, says, well, they talk about the reasonable expectation of use in prosecution isn't on the part of the declarant. Doesn't that solve the problem? And yes, it does.
Okay.
So yeah, I think that if you've got an undercover officer who's trying very hard to get evidence from somebody, but that person has no idea that he's talking to an undercover cop, that's not testimony. He's not testifying. I think it's entirely the declarant is the speaker, that perspective.
Yeah. So, well, that's interesting, because then in the context of children, that actually is quite controversial, because what as I described it, what the state does now is through child advocacy centers, they bring a child in, the child is questioned by a person who doesn't identify themselves as being with the police. The child doesn't have any understanding, doesn't have a full understanding of what the interview is about. The child is still motivated by a desire to stop the abuse, wants the perpetrator maybe incapacitated or rehabilitated, and there's language in the Supreme Court case Bryant that suggests that's non-testimonial. And so the state can produce a videotape totally without violating Crawford by not giving the defendant any right to cross-examine the child. And so I think that's a positive development, but I view it as quite controversial, because if you read the lower court cases, they're saying things like, well, if the police call the interviewer in, then it's testimonial, or if the police are behind the screen, then it's testimonial. But if we agree that the child's perspective is all that matters, I think that's actually a big breakthrough for child abuse prosecution.
I've argued that from the very beginning. I think the court messed it up in Michigan v. Bryant. Now, having said that, I wonder, I mean, what you'd say about the 15-year-old case, where you have a 15-year-old or an adult who speaks to a social worker, and the police prosecution is never mentioned. We can talk about purposes, but I don't think that's the answer. I don't think that should be the standard. I mean, the Supreme Court has talked about the primary purpose of the conversation, which is, oh, come on. I mean, primary purpose. People have multiple purposes, you know. But if everybody in the room understands that social worker is going to take the statement and report it to the police, how is that person not testifying before the social worker? And if we have a system in which this happens over and over again, and then on TV shows you see social workers having these interviews, and then the evidence gets admitted, everybody understands that. So then we've created a system in which instead of testifying in court, it's testifying in front of a social worker. That, I think, is unfortunate,
So-
if that happens.
But then it's, where do we draw the line? Because you're saying a 15-year-old understands when they talk to a teacher, probably, that it's going to go to the police.
Yeah. I don't think
So-
I don't think LT did. Somewhere in between, there's a line.
Yeah, it's probably around 8 or 9, by the way.
That could be.
Yeah,
Yeah.
that covers a lot. And
Yeah.
can I say one other thing about how Crawford has changed, Clark may have changed Crawford? Because I'm really interested in hearing your thoughts, Richard. So the other thing I worry about, well, I actually am excited about, but I worry about for Crawford is I think what Clark recognized is that when a victim complains of a crime, the victim's motivation, even when they're talking to the police, is not in anticipation of prosecution. And one of the things that came up in Davis and Hammond was, surely when the woman calls 911 and says, will you send the police out, she wants the guy arrested and she anticipates prosecution. And yet the research suggests that a substantial percentage of women who call 911 don't want the man arrested, definitely don't want prosecution. They don't anticipate that the police are going to arrest and prosecute because their experience is that they won't. I mean, even in states with mandatory arrest statutes, the police don't arrest most of the time. They go out on domestic violence calls. And so when Clark starts to recognize a little bit more about the dynamics of child abuse, one circles back around to domestic violence and say, hey, maybe Davis and Hammond was too quick to say that as soon as the guy's out of the home, we no longer have an emergency and this should be considered testimonial hearsay. And so if I was a domestic violence advocate, I'd be shouting about how we ought to reformulate our thoughts about domestic violence prosecution.
In Hammond, which as Thomas says, it was my case, in Hammond what happened was the police came to the home, somebody called 911, I think it was the daughter. The police came to the home and came in and kept the husband at bay while one officer was with the husband while the other was sitting down with the wife in the living room. And he asked what happened, and then she described an assault, and then he gave her an affidavit to sign. And it's like, oh, well, come on. How does she not expect prosecution at that point, or at least further legal proceedings of some sort? And as I say, if this is used over and over again, you've got to understand that there's a substantial probability of that. In Davis too, I think that she wanted him picked up, but she wanted restraint. At least she wanted the legal system to get involved. And so I think that I mean we could argue about the whole emergency and I mean the oddity there was they said the Supreme Court said there was an emergency, but for goodness sakes, if there's an emergency, you don't go and try to find the guy. If there's an emergency, go to the house and protect her. But they said we're going to go out and find him, and then we'll come and talk to you. You know, she wasn't afraid that at that moment he was coming back. So if there was really an emergency, they would have done something different.
Yeah. So
I didn't argue Davis. Jeff Fisher lost Davis 9-0. I won Hammond 8-1. The difference was lawyering.
yeah.
Yes. And I was struck actually by the choice of this topic as being somewhat non-ideological, especially when I looked both at what the splits were on the decision and really the nature of the arguments are not as conducive to the conception of the Supreme Court as taken over by one ideology and another, although I think those of us who think Roberts can make thunderous proposals now and again, like that a penalty is a tax in a thunderous way. But I take your point. My question though is to Tom, your concept of forfeiture, my concern about that is that it essentially suggests, as you did kind of accidentally or slip of the tongue, that there's a perpetrator. I accept that if a child's been traumatized, you know, in essence, there's someone who has been a victim of something. Of course, the process is to find out if they were a victim of the type of criminal abuse that we're out to search. So I just find that as an irreconcilable standard, because it essentially requires that we assume the guy was a perpetrator to begin with in order to say that his choice was to perpetrate somebody who couldn't well testify against him.
Right. So actually, Richard, you have the best answer to this. It seems circular, right? Is that you're presupposing what the trial is ultimately supposed to determine, but forfeiture is a judgment that a judge makes outside the presence of the jury as to the admissibility or inadmissibility of evidence. And it's often the case that the judge will decide something that the jury is also going to decide at the outcome of the trial. So, for example, there's a hearsay exception for statements made by co-conspirators. Well, in order for a hearsay statement to be made by a co-conspirator, there has to be a conspiracy. So what happens if the defendant is charged with conspiracy and the prosecutor offers a statement as a co-conspirator statement? The prosecutor has to prove, outside of the presence of the jury, to the judge that there was a conspiracy. And then the judge lets the evidence in. So the judge has to decide whether the defendant is guilty of the crime in order to decide whether to allow the evidence to be presented to the jury. And then the jury makes the ultimate decision as to whether the conspiracy is true or not. So this happens all the time. Similarly, in a forfeiture case, a typical forfeiture case would be one in which the defendant is charged with murder, and the prosecutor wishes to use the forfeiture by wrongdoing exception to allow the statements of the victim. Well, the jury is going to decide whether the defendant killed the victim. The judge, in applying the forfeiture by wrongdoing doctrine, is going to have to decide if the defendant killed the victim. And so it's often the case that the judge, in making an admissibility determination, will decide the same issue that the jury is making, but the judge does it by a different standard, the judge does it outside the presence of the jury, and the judge is making an admissibility decision, not the ultimate decision. And I hope I've said that clear. I'm sure you can.
Well, I mean, yeah, Tom is right that I had the best answer. No, I mean, he said basically what I've said over and over again. I mean, basically, the short of it is that there are two separate determinations that have to be made for different purposes. They happen to be made by different people if there's a jury trial, one by the judge, one by, so the only thing I might say a little bit differently, the judge doesn't have to determine is the defendant guilty of the crime. The judge has to determine, did the defendant do something that forfeits the right? So
But oftentimes that is the
often it turns
yeah.
out to be the
Yeah.
same question, but it's the same question asked of different people for different purposes. So, if I may, I just want to go back to your point about ideology. It's very interesting. I think it is ideological here. I think, say, Scalia, who's been in the forefront of the whole development of the Confrontation Clause, it's a very ideological view of preserving the Constitution as written, preserving the rights, adhering to them, of having clear, strong walls, if you will. It's just not the usual ideological split that we're used to, where there's a tendency to think all questions can be, you can line up 9 justices in one dimension, and a given case is going to slice them somewhere along the 9, and so it's impossible. But there are many different dimensions, and that's why you get the kind of split that you have here with Scalia and Kagan being very, very close together on these issues. Yeah.
So I want to stop on time, but I first want to say that what I've always really appreciated about the Political Theory Project is that it has brought to Brown events where people disagree in a reasoned and civil way. And I think we've had that today, and I appreciate that so much, and I want you to join me in thanking both these professors.
And thank you all.